seated.
I like your chair better. Call the State of Texas versus DWAYNE Robert Heath, PD 015622. Please proceed.
May it please the court. My name is Emily Johnson-Liu, arguing on behalf of the state. The most consistent and natural meaning of state in Article 3914 is the prosecutor's office. Heath's argument that it also includes the sheriff's office and any other state or local government entity reads back into Article 3914 language that was struck by the Morton Act, the language the state or any of its agencies. And this ignores the principle that significant changes in language by the legislature.
Excuse me a moment. Are there seats for our guests in the back? Okay, thank you.
That interpretation ignores that significant changes by the legislature signifies the presumption that significant changes
Counsel, isn't there a specific reference in 3914A to counsel for the state?
Yes,
And then there's also references just to the state.
that's right.
Doesn't your reading make the reference to counsel for the state redundant?
It doesn't make it redundant, but there may be, yes, some overlap between counsel for the state and state in our interpretation. I think that it doesn't render it meaningless because in that particular section, it is important to clarify that multiple entities within the state, the DA's office, including attorneys and their investigators, there's a need to specify those particular roles within the DA's office. So I think that's why it still has meaning, even though, yes, there is some overlap generally between counsel for the state and state. If there is a choice between this bit of overlap and ignoring the presumption that a significant change in meaning is a significant change in language is a significant change in meaning, then obviously the better thing would be to have a little bit of overlap in that language. In addition to that, there are other numerous statutory evidence, textual evidence, that our interpretation is superior.
So, Michael Morton, we all know about Michael Morton. It was my understanding that Michael Morton, that act was meant to codify Brady, which under Brady, law enforcement would be considered an agent of the state.
So H, 3914H, is the provision that deals with exculpatory impeachment mitigating type of evidence. And that is the closest thing that is a codification of Brady. But of course, we have Brady law that exists in addition to the Michael Morton Act. And the Michael Morton Act, particularly in A, which is the section that we're dealing with here, that goes well beyond due process concerns of Brady. And so, again, it's really the language that this court, that the legislature passed, that this court is interpreting, and not sort of what were particular legislators trying to do with passing the Michael Morton Act. And certainly 3914A, I don't think anyone considered to be a codification of Brady because it goes well beyond any exculpatory stuff. It's inculpatory evidence too.
Practically speaking, how do you see this working if the law enforcement has something that is considered exculpatory? How do you see this working? You know, are we going to just have a lot of cases where at the last minute the prosecutor finds out that the police had something and didn't hand it over and too bad?
No, it's not a too bad because obviously there are remedies even with our interpretation of the state being the DA's office. if there is a last-minute disclosure, even like by a third-party witness that comes in and brings a piece of evidence that nobody knew about before, this kind of last-minute stuff does occur in cases, and there are remedies that a trial court has, even if there's no violation of discovery, to grant a continuance, to give a mid-trial recess in that situation. But more than that,
Counsel, where in the statute are there remedies, though? I mean, one of the good and potentially bad things about the act is that it removes the involvement of the court. So where do we draw from the statute some ability for the court to enforce or fix or hold the state to its duty to disclose things?
I don't think that 3914 offers any of those remedies. There's nothing express. And I think negative implication, it does not authorize anything statutorily. But the Code of Criminal Procedure provides for remedy of continuance when there's good cause. And that can come from even if there's a late disclosure by law enforcement or a third-party witness completely separate from any law
Where do you
enforcement.
see labs falling?
Some labs are going to have a contractual relationship with the DA's office. And where that occurs, I think that 3914A would say that the DA's office and those that it has control over, those that it has taken up contracts with, will be included in the requirement to disclose. Not all labs will have that sort of contractual relationship, or where they do, I think it's provided for.
How is your theory going to impact the policies of the police department and labs? Do you have any idea?
And I meant to say this earlier, I don't think it's going to have that kind of impact because there is still a due process requirement, and because of the motivation DAs and police agencies, labs all have to get evidence to the trial process. And the responsibility of prosecutors, both ethically and under Brady, to make sure they have everything that's exculpatory, impeaching, mitigating. They are going to be motivated to get this information regardless of how this court interprets 3914. So I don't...
Well, I'm sorry, counsel, like, getting to interpreting Article 3914, if we read the state the way that you're asking us to read the state, isn't that going to create a scenario where law enforcement has no real, or the state can always say, I got it, I turned it over as soon as I got it, but I'm the state, so I never had it. So they'll always be able to say, well, law enforcement doesn't have to give me anything because the state isn't law enforcement. So I have no obligation to get it from law enforcement, except for my ethical duty for Brady, but I have to get anything from law enforcement.
Well, but the ethical and Brady responsibility is not nothing, because at that point, if you don't have the evidence, you don't really know what it is. You don't know if it's exculpatory. Right. So a prosecutor will need to get that information. The problem with 3914A, as far as the inculpatory and neutral evidence goes, is that it doesn't have a scienter requirement. That it doesn't require prosecutors to know that this evidence even exists. And that's a sign, I think, that it wasn't meant to be telling prosecutors go after and find stuff. The other state statutes that have that sort of duty in their discovery statutes have a requirement that the prosecutor know the evidence exists before they're imposed a requirement of going after and fetching it. And that's sort of just a practical implication too.
But certainly you would expect a prosecutor getting ready for trial to have at least talked to the police about what they have long before trial, not months and months later?
Absolutely. And in this case, there was discovery that happened. Offense reports were given out when the prosecutor read the offense reports and saw that there was a reference that photographs had been taken, and she didn't have those photographs. She went back to the agency and said, give me those photographs, and then those were turned over to the defense. So yes, all this kind of stuff is ongoing and happening in cases, and I expect that even with this interpretation of 3914A, that would continue. The prosecutor wants to have all of the evidence in the case anyhow. The labs, the police agencies, they're motivated to get all of the evidence that they have that's relevant to the case over to the DA's office too. So I really don't think it's going to have a significant impact on how things are operating on a day-to-day basis. There are going to be times when last-minute disclosures occur, and I think that within trial judges' normal, everyday remedies that they have for continuance would be able to.
I'm sorry, counsel, but isn't really one of the things that motivates prosecutors is the fear that this evidence could not be admitted if they don't get it quickly to the defense? I mean, as a former prosecutor, that was one of the things that always concerned me. If I don't turn things over in a timely fashion, the judge could hold it against me and suppress the evidence or exclude the evidence. So isn't that one of the reasons why people are motivated?
I think it is a motivator, and I think when the prosecutor knows that there is evidence, has the evidence, sits on it for a long time, you could establish a bad faith situation where there is a violation of 3914A and there is a sanctionable remedy solution. But that is not this case. And in addition, there are a number of other sort of indicators in the language of the text that state really means DA's office. Because in order to hold one agency responsible for another agency's failure to disclose, you really would expect some level and ability to control. Other state statutes that have imposed similar responsibilities have impose instead a duty to sort of use diligence to obtain it from a different group that it doesn't have control over. None of that language is in our statute either. If we were to impose this sort of responsibility for getting stuff from a police agency, that would create tension between the prosecutor and other elected officials. It could violate the Civil Service Act, as I mentioned in the brief. It could intrude on intra-branch sphere of authority when you're sort of intruding on the practice or the employees telling employees of a different elected official what to do.
Did we have all those problems before Michael Morton?
I think there is, under Brady, there is a sort of natural working relationship. I think DAs brought in their police chiefs and said, you know, you've got to help us in this action. We need this evidence. But in order to impose responsibility on the front end, as opposed to deciding if there's a Brady violation on the back end after everything, then you really need an ability to control. In order to practically require someone to go and get stuff from a different agency, there needs to be an element of control that's not there. Under Brady, you can impute backwards because it doesn't matter if the state didn't know about it, doesn't matter if the state has it or not, because you just look at what has already happened in the past. But as Watkins recognizes, this is a discovery statute, and it's not supposed to be sort of aspirational. This is a practical, how are we going to do this stuff? And if you don't know about the evidence, it's hard to say you have a responsibility to go and get it from somebody you don't have the ability to control. In addition to that, I will say on the second issue, the exclusion of relevant evidence is an extreme sanction. So even if this court doesn't go with my interpretation of what state means here, it needs to be a really extreme situation. The prior case law that interpreted when you can exclude evidence for a violation of discovery had to do with willful violations of a discovery order. And that became sort of a stand-in for bad faith when you can ordinarily do that.
But counsel, aren't those cases saying, yes, obviously in that circumstance you can do that, and you can exclude evidence when it's a willful violation, but it's not necessarily the trial court doesn't have any authority to do it even when there's not a willful violation. I mean, the trial court could still exclude it. It doesn't necessarily, just because those cases have all centered on the idea of bad faith, doesn't mean that the trial court is limited in their ability to exclude only in those circumstances.
I don't know of authority in those cases, and maybe I'm not following you.
It's
That-
entirely possible that I didn't ask any question.
I'm sure it's my fault.
No.
Like, I don't, it usually requires either sort of, you deliberately, you knew about what the trial court was ordering you to do.
Right.
And you deliberately disregarded that. Or going under Judge Cochran's interpretation, something less than that, but you had prejudice on the other side. So, but if you don't have either of those two things, as in this case.
I guess what I hear what you're saying. I do hear what you're saying. You're right. But I guess what I'm wondering is, doesn't a trial court have broad authority to sort of fashion whatever remedy they think is appropriate for the particular violation? Why is it that we have to say only in these circumstances is this exclusion required?
Well, I think because Morton doesn't provide a statutory remedy, you're falling back on inherent authority. And so that's, you're not exercising power that the legislature has given you.
Yeah.
You're only doing it based upon your sort of to function as a court, you need this power.
Yeah.
So if that's true, then it's got to rise to the level of whatever is going on in the court is making a mockery of justice, and all those things are sort of the level of bad faith. And that's why I think that has to be the test here. You don't have bad faith. The trial court has found that specifically. In addition, the defense pretty much says, I don't need more time. I don't want more time. I just want to go with the evidence that we had before, not this new stuff that's coming. So you don't have prejudice to the other side. And when that's the case, then there should be no remedy.
Hasn't history proven that unless there is a fear in the prosecution and the state that they may lose their evidence, it may be excluded, that there are some counties, some district attorneys who are just not going to give the defense anything unless they fight tooth and nail with the judge to get it?
I still think that when, I'm not aware of the situation of prosecutors that's their motivation, but I'm willing to entertain that exists.
I am. I practiced back then before Michael Morton, and I can promise you it was the case.
Trial judges will still have authority in extreme cases to find violations, to use that sanction. So that if that is the only thing that is motivating these prosecutors, that still exists, and the trial judge will still have that power.
Thank you, counsel.
Good morning. May it please the court. Jessie Freud for Mr. Heath. In 1978 in Hollowell, this court said a prosecutor has a duty to know what evidence is at its disposal. And of all the changes made to 3914 since, eliminating this duty when a request has been made is not one of them. In its PDR, the SPA is asking this court to construe state in a way that would lead to an absurd result, conflict with this court's decision in Watkins, and also conflict with subsequent statutes and other constitutional obligations. As the SPA said on page 20 of its brief,
Counsel, doesn't your reading of the idea of the state as any law enforcement agent or anything is broad reading of the state, doesn't that lead to sort of the situation where the defense can simply go ask law enforcement for this information? They don't even have to involve, doesn't sort of court then to reach out to law enforcement to get this information without even involving the state?
no, sir. And I was really surprised that the SPA had a concern that this ambiguity somehow would make the defense think that we have to go request 3914A discovery from law enforcement and not them. I don't think anybody has ever thought that
Well,
this
some people
creates
in
an
Lubbock did.
this creates an ambiguity where law enforcement all of a sudden becomes the direct production agent. I don't think that is a reasonable interpretation. And again, on page 20 of their brief, they admit that the construction that they're asking for is not the norm in criminal law. And especially when we're talking about the overall codification of Brady in the statute, like Judge Hervey was just talking about, that has always implied the state. And so if one of the objectives of Morton was to increase and make sure that mitigating and exculpatory and impeachment evidence is turned over to the defense, why are we going to essentially create two standards where you have this theoretical Brady obligation, but then you're not responsible for marshaling the information from the entities that create it? I mean, prosecutors, yes, they can have an investigative role, we all know, in a case, but practically speaking, we know that the bulk of that work is done by its agencies and contractors, which is why the obligation, as y'all said in Hollowell, to know the evidence at your disposal is so important.
The state's not at fault. Why isn't a continuance the appropriate remedy? When I say the state, I guess I should say the DA's office or the prosecuting agency. Why wouldn't either they offer, or why wouldn't you just ask for a continuance to review the evidence that has been withheld?
Yes, sir. I believe that would absolutely be a remedy within the trial court's discretion, but we're on an abuse of discretion standard, and so the trial court should not have been obligated to only have a continuance as the remedy. Particularly in this case, anybody that practiced in the 54th would know that if you're on your 4th jury trial setting and your judge has a panel in the hall and you've announced ready on 3 prior occasions, a continuance really doesn't resolve the issue for you, and I think that that's what the reporter's record in this case reflects.
It would resolve the issue, it just prolongs the inevitable of the trial, correct?
Correct,
You
yes,
have
sir.
the time to review it. You just have to wait longer. If your client's in custody, then he's just sitting in jail for another.
Correct. I
3,
think
4,
it
5, 6
presents a
months.
false choice for defense attorneys of, do I keep making my client wait when the folks on the other side have said on 3 prior occasions they're ready, or do I try and enforce my client's right to due process and to know all the evidence against him?
So this 911 call was not divulged until the jury panel was in the hall?
6 days before trial.
6 days before trial?
Yes, ma'am. 6 days before trial.
So not at that point, okay.
Yes, ma'am. The way the motion, and it was filed a little bit strangely as a writ and a motion kind of hybrid, but that was taken up the morning of trial while the panel was waiting outside.
May I also ask, so do we know if this 911 call was exculpatory?
No, ma'am, the record is silent as to
We
its
don't know
contents.
its character.
Correct, yeah, there's no characterization as to whether it was just inculpatory evidence or exculpatory evidence.
And counsel, with a leeway of 6 days, shouldn't defense counsel have at least argued that he did not have time to prepare given this new evidence and would not be ready for trial within 6 days? Because he didn't make that argument, did he?
He did not, no. He said he was ready for trial based on what had been produced.
Okay, and so the introduction of this new evidence, the 911 call, didn't impact, or he at least didn't say it impacted him in any way?
The record is silent as to what he may have thought the impact on the case would have been. The record says that he was ready based on what was produced, and it did not appear that he had contemplated or told the trial court how that may change the defense.
But he might have asked for that had he not been successful on having it suppressed.
Correct. That may have been the alternative argument. I don't think we know either way.
Can we infer that it was not exculpatory since he wanted it suppressed?
I don't know. I don't know. I don't want to say yes, because I also, with the timing issue, I would hope that there was in those 6 days, even though it was within a week of trial, that there would have been the opportunity to really listen to it, but I don't think we know either way.
We don't even know if he heard the tape?
I don't think the record is clear. I'm assuming so, but there really isn't a conversation about the extent to which he was able to listen to it and feel like he had sufficient time.
So, counsel, you mentioned the case where the idea is that the state is responsible for knowing the evidence that's at their disposal, but how would you describe a prosecutor's responsibility to, I mean, are they supposed to, you get a file, whether it's paper or electronic, and you just review the file? Like, how would you describe the responsibility of a prosecutor to find evidence in a case?
So I think there are commonalities in every case. A case gets started somehow. The record does reflect that the prosecutor made the point that in injury cases, or what we probably all call CAT cases, that 911 calls are less frequent than in some other kinds of cases, but a case gets started in really a handful of ways. And so I would think that in order for the prosecutor to understand how their case got started, a 911 call would be a pretty common sense way to
decide whether or not that was a part of the beginning of the case.
But, I mean, but more broadly, I mean, obviously this case is about a 911 call, but just more broadly, do you think a prosecutor has a duty? Like, do you want us to impose a duty of the prosecutor to go out and affirmatively seek evidence? And if so, like, how far does that duty extend in your mind?
So again, I think the court has already done that. The only difference I really see between Hollowell and this situation is a motion and order versus a request. And so I think that duty, I don't think that duty's changed just because we're now magically not dealing with a motion and order and a request, right? This court had said in Watkins, we're trying to make discovery easier, broader, and more accessible. And so I think that the duty hasn't changed, even though the procedural mechanism by which it's obtained has changed. And so I think that duty exists now.
What do you think is the definition or meaning of as soon as practicable?
It is definitely not 14 months, 3 jury trial settings and announcements of ready, which also include 8 announcements of ready between the ultimate setting. I think it is not from the point in time the prosecutor has actual possession of it. I think there are probably 3 ways that you can decide how you want to calculate as soon as practicable. I think one could be the date of arrest. That may be a little too harsh. One could be date the case is turned over to the prosecutor. I think that's pretty reasonable. The day you decide I'm going to take it over and decide whether or not to prosecute it, that seems like a reasonable point in time the obligation would be triggered. And then third, probably the point in time that would be most beneficial to the state would be the date of the request, right? That is the unequivocal point in time during which the obligation is triggered. So I think you have 3 options, and I think 2 and 3 are probably the ones the court needs to think about most closely.
And would that apply to evidence that the prosecutor had no reason to know existed, not like a 911 call, but some witness he had never heard of coming in a few days before trial? Would that still apply?
I think that at least there is the better argument that that is newly discovered rather than a piece of evidence that has been in the possession of the state since the case's inception. So
The statute doesn't make a distinction, does it?
as soon as it's available. And so I think the construction of available to the prosecutor I'm asking for is essentially the date law enforcement has it, because that's who starts the case. Otherwise, I think the date that it would become available would probably be.
So that's why we have, I'm sorry to interrupt, that's why we have to interpret state the way that the state applies to law enforcement, not just the attorneys representing the state, according to you.
Correct, yes, sir. That, again, the construction the SPA is asking for is a narrower construction. They admit that the pre-MMA construction, that there are cases that always included law enforcement, and most orders, when they would be sought, would include law enforcement. And so now they're saying, we know everything's changed, we know everything's broad, but this one area we are now narrowing to just our possession, when pre-MMA that just wasn't the believed construction.
Was there a discovery request that would have covered the 911 tape before the 6 days before trial?
So the sufficiency of the request issue, when y'all took that up on the first PDR, I think that because that wasn't raised in the 10th, that issue was waived, and so for our purposes here, the sufficiency of the request isn't at issue, but there obviously was a discovery request.
There was a discovery request. I'm asking, were there multiple discovery requests is kind of what I'm getting at. Was there a discovery request a long time ago, you're getting ready to try the case, before the state ever announced ready the first time? Give us everything you have, and then there's a specific request that becomes the issue that leads to the exclusion.
No, sir. I believe the clerk's record only reflects the one request from March 20th of
Gotcha.
2017.
Okay. Yeah, that's what I was, thanks.
Getting to the second issue about the trial court's authority to exclude this evidence, we know the trial court's authority can come from 3 places: Constitution, statutes, and the common law. And as a part of common law authority, they can exclude evidence when there has been a willful disregard. And here, the 3 acts that the court can rely on to say that there has been willful conduct to justify exclusion would be the length of time in possession of the item, and I did a little bit by the numbers, if you will.
So 6 days between the disclosure to the defense and trial, 135 days before Heath's March 20th, 2017 request, 424 total days before the ultimate setting, 8 times the state announced ready, and 3 times the case made it to the morning of trial before the ultimate setting and was just passed because other cases went ahead, and 559 total days that the 911 call went undisclosed. It's a really long time.
Do we know if there was a mention of it in the offense report?
No, sir, there was not. And the prosecutor was very clear on the record that the reason, besides the first reason that she believed 911 calls are not common in these kinds of cases, that the offense report did not mention the 911 call. And so she only found out about it during an interview with a witness 11 days before trial.
Okay.
Again, the number of times the state announced ready. If the state was ready without the evidence, why can it not be ready with it?
But that begs the question. I mean, yes, there's a lot of time happening, but you just said the prosecutor doesn't even know that this 911 call exists until 11 days before, when they talk to the witness, right?
If you've got a case that's this old, I think that's where the duty to know what is at your disposal. If you're prepping a couple-year-old case 11 days before trial, that is too late. That's too late.
But isn't that really common?
Yeah.
Practically speaking, unfortunately, it is common, and I think that's why that's not the preparation I think any of us want to endorse, which is last-minute preparation, although we all know that that is unfortunately very, very common.
And why is that common?
Volume, I think, is probably the biggest reason, volume.
Right.
And then the pandemic, I don't think helped more recently. This was a pre-pandemic case, but I know we're all still really suffering from pandemic backlog.
So would you have the state just send, every time they get a case filed, just like a form letter to the law enforcement agency? Send us, make sure you've given us everything. And wouldn't that be redundant of what the other statute requires, 21397? I mean, you could just send paper back and forth, and it would be meaningless until you actually, I guess, interview your witnesses. Are you going to have the state required to interview all of its witnesses as soon as a case is filed?
No, I understand that that probably isn't realistic, but I do think if you get with your agency and you get with your lead detective, they're going to tell you how the party started, so to speak. And again, a case only starts in a handful of ways, and a 911 call is a very common way that a case starts. But speaking to 2.1397, because I know there is a disagreement between us and the state about the subsequent intent that we may be able to infer from that. And I think what 2.1397 reflects is that prosecutors do have an obligation to know the evidence in the custody of their agencies. And so in order to help them fulfill that obligation, 2.1397 says, law enforcement, you have to tell us and certify that you have given us everything because we're responsible. And so I don't remember if it was the first or second time, I think this bill had passed, the third time it came up, when I had actually testified on that bill in front of the Criminal Justice Committee, and that was a part of the conversation, which is prosecutors have an obligation to know what we have. How do we help them fulfill that obligation? And 2.1397 helps them do that by saying, y'all understand you have a continuing obligation to keep us updated on what is in your possession.
So counsel, how would you describe, so a defense attorney sends over a letter or email or whatever that says, give me my discovery. How would you describe the defense counsel's obligations after that letter is sent regarding discovery? I mean, are we relieving defense attorneys of any obligation to do an investigation at that point? And are they just passive consumers of whatever the prosecutor sends over?
I think the sufficiency of the request and what a proper request looks like isn't the question here, but to try and be responsive to what you're asking. I think that a defense attorney's obligation is obviously always to be thorough and to zealously represent their client. And of course, that includes going through all of the discovery and doing your own investigation. And as a part of that, there are ways we understand cases begin, but then obviously because law enforcement are not our agents or the agents of the state, there is information we don't know, and I think this case is a really good example of that.
But I guess in a situation where, let's say, I'm changing the facts of the situation, but the defense attorney knew that there was a 911, somebody called 911, didn't request the tape, didn't request a 911 call, and then we're in this situation. I mean, does that matter at that point? Like, if it's evidence that the defense attorney knew existed, but the state never turned over, does that matter in your analysis of a trial court's discretion in this case?
Can you say the last part again? Evidence the defense.
So the defense knew that there was a piece of evidence that existed, but the state never turned it over. And then, but then right before trial, the state says, "Oh, you know what? We're going to use this piece of evidence after all." Can the defense attorney? I mean, how does that play into the mix of whether or not that trial court has discretion to exclude that evidence, even if the defense side knew that this evidence existed? Like,
I think that scenario is really similar to Watkins in that, right, there was notice of the prior convictions that were
yeah,
used
they just
for
didn't have the
enhancements.
judgments. Yeah.
And they just didn't have a copy of the judgment, so there was notice, they knew, but they just weren't given a copy of it. And when they came to admit it, obviously it was admitted, and then y'all decided that that was something that they had a right because a request was made. And so I think that that situation I think this court has addressed that situation. And that's, even if we know, they still have an obligation to produce, and that our obligation is satisfied once we make the request.
Counsel, do you think that there needs to be a willful violation, or do you think that there doesn't need to be a willful violation? Like like, as I understand the opinion below, the exclusion was allowed based on the idea that it doesn't have to be willful. Are you saying that it does have to be willful, and that it is willful in this case?
I think the way the 10th handled that was almost blending that with the timeliness component, the addition of as soon as practicable.
Okay.
And so I think there was still a consideration of the willful conduct, but I think ultimately what they decided was the timeliness element is
Right.
really what controlled.
So I guess what I'm getting at is, do we say, are you asking us to say, not only is there this requirement of willfulness, but also this was a willful failure to disclose and uphold the exclusion? Or do we need to say there is this willful requirement and we need to send it back to the 10th court to determine willfulness?
I think you can say that there was willful conduct for the 3 reasons we just went through: length of time of the possession, number of times announced ready, and failure to marshal the evidence in a timely manner. And so I think impliedly that those are the considerations that were addressed by the 10th that this court should affirm.
Was there any excuse provided to the court on why it was overlooked or not turned over?
Yes, sir, there was.
And that was, we just didn't know it was there, or law enforcement snapped to and said, hey, we've got this? What was it?
Why it wasn't in an offense report specifically, I don't think was addressed, but it was addressed why she didn't know about it, and that was because she said it was nowhere mentioned in any of the reports. The trial court's role has not been eliminated from the discovery process, although it has been limited. One of the authorities that has looked back in December of 2014 on the changes the MMA made was that we don't have to do a motion or order anymore, we only have to do a request, but the trial court's involvement can still exist, and I think there are kind of 2 really common examples of that. If the state has an item of evidence that they are not sure needs to be produced, you go to your judge and you say, hey, can you help me decide if I need to turn it over, and order me to turn it over. So I think that's one very common way the trial courts are still involved, even though we have severely limited their participation in the discovery process. And I think another way is going to be with protected records, particularly in a case, an injury case or a CAT case. CPS records are obviously only records that can be produced with an order because they're confidential, and that comes from the trial court, and that still happens routinely even with a request. So we still make a request to the state for CPS records, but they can't give them to us until they get a court order. And so when we're talking about what is the trial court's involvement in discovery, I think it is limited. It has been severely limited, and the court has found that, but it has not been eliminated. I've got 1 minute left if there are no more questions. Yes, ma'am.
What's probably a really dumb question. What is a CAT case? Is that what you're saying?
CAC, yes, ma'am. Sorry, crime against children case.
Okay, all right, thank you. I hadn't heard that before.
Yes, ma'am. And for all these reasons, I would ask that this court please affirm the decision of the 10th Court of Appeals. Thank you, counsel. Yes, ma'am.
So an important part of the sanction and remedy issue is what was the point of discovery. It should be about getting a fair trial, getting access to evidence. And as a result of that, the remedy should be scaled to whatever the problem with the violation of discovery was.
But counsel, what about the idea that, hey, the state said they were ready with this universe of evidence, so we're not really doing anything to you. You said you were ready with the evidence you had, so how is the state being harmed by the court saying, well, you've told me you were ready 3 times before, so?
Sure. Well, I mean, the state, in terms of like the people of Texas, have entitlement to all of the relevant evidence, and exclusion generally is an extreme sanction. Even though the state could have put on a case, when it discovers relevant evidence, that's a situation when all of society benefits by hearing that relevant evidence. And I think that's a consideration.
Question for you regarding maybe a trial court's docket control order. Say that a trial court has a docket control order that sets a date for all evidence to be turned over, or else it will be excluded. How would something like that factor into this type of scenario?
I think it would, without any finding of bad faith, and where perhaps not even law enforcement witness, if some other completely third-party witness comes forward with evidence at the last minute, it was probably an abuse of discretion for the trial judge to stick with that standing order. I understand of course, a trial judge has sort of inherent authority to control its docket, and she may want to make sure things are done in an efficient way. That's all laudable. But things do happen. The late disclosures occur, and I think the trial judge needs to fashion the sanction based upon the error that occurred, and where nobody knew about the evidence existing, and it's negligence at best, and it's no fault of the prosecutor at all, then you have to sanction a remedy that's fitting for that situation. And the defense attorney, if the defense attorney knew about that evidence ahead of time, well, they should ask for it. If they want to hear the 911 call, you know it exists, the state hasn't turned it over, then ask for it so we can give it to you. The whole point is that you have access to the evidence. It's not to trap up the state so that you can have the windfall of not having that evidence be admitted at trial. That's the point of discovery. There's other remedies if it's it's impeaching evidence, if it's favorable for the state. I get that. It's totally different than what we're talking about here.
But counsel, I know you're out of time, but this all sounds good for us to say, yeah, the remedy should be this. And if I were sitting as the trial judge, I probably would have said, well, I'll give you a continuance or something. But isn't the question really, aren't we supposed to say, well, can the court do this, not how the court should do it? Isn't our question really whether or not the trial court has the ability to fashion whatever remedy they want? And how is it we're limiting their authority to do that when the statute doesn't actually speak to it at all? To speak to any limitations on the trial court.
Again, I think it goes back to they only have the authority under inherent authority. Mm-hmm. And if you don't have bad faith, you just don't have discretion to fashion a remedy.
So you're saying that would be an abuse of discretion?
Yes.
Right.
Do you have a position on whether or not the tape is inculpatory or exculpatory?
Because the defense pressed hard to keep it out, the state pressed hard to admit it, and the state said it's significant evidence needed in order to go forward with the state's appeal. All signs and everyone acting is that this is inculpatory evidence. Thank you.
Thank you, counsel. The case is submitted. Calling out cause number PD 070022, Marlon LALL versus the state of Texas.
May it please this honorable court, for those of you who might not remember, I'm Brian Wice from Houston, and it's my privilege to represent the appellant this morning. 80 years before the advent of body cams and drug-sniffing dogs, legendary Supreme Court Justice Robert Jackson famously said that in law, a search is good or bad when it starts and doesn't change character from its success. 65 years later, this court reaffirmed this fundamental tenet when it said that an investigative detention is good or bad when it starts and does not change its character from its success. Viewed against this backdrop and through the non-deferential lens of de novo review, it is clear that this investigative detention was bad from the moment that Deputy Jordan Pope impermissibly extended his investigative detention by bringing out his drug dog to conduct the drug sniff without having formulated reasonable suspicion after the purpose of that stop had concluded in violation of the Supreme Court's opinion in Rodriguez. There are three equally compelling reasons why this court must jettison the majority opinion of the Fifth Court of Appeals. First, because the appellant's assertion of his constitutional right to refuse to consent to search was, as Judge Cochran noted in Wade, the tipping point, the linchpin in Deputy Pope's reasonable suspicion analysis. This case is controlled not by Matthews, as the state wants you to believe, but by Wade. Secondly, not by dividing and conquering, but by adding up the collective probative value of the factors the state claims gets it into the end zone of reasonable suspicion. None of them come
How
close.
long did this whole thing take? Do you know?
From the moment that Deputy Pope pulls the appellant over for 2 traffic violations, the substantial part of that, I believe, is probably 10 minutes. And once that traffic stop has been effectuated, at that point, Deputy Pope tells the appellant, I'm going to give you some warnings. And under Rodriguez, that moment is etched in stone. It's etched in amber. And from that point forward, unless Deputy Pope has developed reasonable suspicion during the stop, that's it. The third reason why the Court of Appeals opinion is a non-starter is that it is at odds with a cavalcade of case law from this court and the courts of appeals, finding no reasonable suspicion on facts far stronger than those in this case, cases that the state has consistently refused to acknowledge or distinguish, as well as the video itself, which the state refuses to acknowledge its significance. Look, John Adams said the facts are stubborn things. There's a couple of really stubborn facts I want to make the court aware of. Number one, Deputy Pope acknowledged that in the wake of the traffic stop, the appellant did everything he wants somebody out on a traffic stop to do. He's a first ballot Hall of Fame suspect. And secondly, once the purpose of the traffic stop had been effectuated under Rodriguez, Deputy Pope admits he had, quote, 0 indicators there were drugs in the car. But nonetheless, he brought out his canine, Czar, the hero of this story, because he felt there was, quote, some kind of reason to bring in the canine. There are 2 other facts, air quotes, that don't figure into this court's determination. One, the now famous heat run, which I haven't heard since season 2 of Miami Vice. It's not in the trial court's fact findings. Under Mendoza, it's out. And number 2, the notion that Pope knew that prior to the traffic stop, the appellant had been recently present at a location where drugs were, quote, suspected, close quote. This assertion is patently, painfully, purely conclusory. It doesn't give anybody in the free world any idea as to who, what, where, when, why, or how they came across this information. And I submit that it shouldn't enter into this court's reasonable suspicion analysis. And it's also at odds with a couple of cases the state pretends don't exist. The Court of Appeals decision in Richardson and this court's decision on Markopoulos. And yes, I understand Judge Kiesler's opinion dealt with probable cause and not reasonable suspicion, but it is still eminently relevant. The simplest way for this court to turn this case around and get on an opinion before Rosh Hashanah, spoiler alert, I think it's in October, is just to do what the Court of Appeals refused to do and what the state won't do. And that's fully and fairly apply this court's holding in Wade. And in this court's holding in Wade, the late, great Judge Kathy Cochran, in an 8-0 opinion, said that because appellant's refusal to cooperate was accompanied only by his extreme nervousness and the game warden's hunch he was up to no good, that the ultimate Terry frisk violated the Fourth Amendment. Full stop. You substitute the word game warden for Deputy Pope, and this fight is over. Referee stops it on cuts. That's it. It's done. And what's memorable about Wade is that there are 7 additional factors that we don't have in this case. We've got the usual suspects. We've got the now famous throbbing carotid artery. We've got the wavering voice, and we've got a refusal to cooperate, which we don't even have in this case. And when you look at Wade from 35,000 feet, if you do more than read almost all of it, almost all the way through, you can see that this case is not about Matthews. They want you to believe that this case is about Matthews. What they want you to do is swing at a pitch in the dirt. It is clear that Wade has a number of distinguishing characteristics that separate it not only from Matthews but make this court's task easy. Number one, Wade was a consensual encounter until it wasn't. This was a non-consensual encounter from Jump Street. Number two, there was no video in Wade, unlike this case, that unmasked the game warden's embroidery. And number three, in Wade, there were no written fact findings that could be used to fill in the gaps on the reasonable suspicion canvas. Look, it is clear that this appellant's invocation of his constitutional right to refuse a search was the tipping point, the linchpin, the capstone. And the fact that it was the last factor means nothing, as the state would want this court to believe.
Counsel, given that, should we write an opinion saying, are you asking us to write an opinion that says under Wade the search was bad, or are you saying the Court of Appeals erred by considering the refusal to consent and go back and redo it without considering the refusal to consent?
Judge Newell, I think the good news is this court does not need to overrule Wade. It doesn't even need to fine-tune Wade. All it's got to do is to do what, again, the majority declined to do and what the state won't do. Because Wade makes this clear that this is a tap-in on 18 for the green jacket. That's it. Very little heavy lifting or outside work. Number two, the factors that the state wants this court to believe gets them into the reasonable suspicion red zone. Collectively, forget about, I don't want to say forget, excuse me, even without regard to dividing and conquering. First, appellant, we've already talked about the fact that his recent presence at a drug location, that patient flatlined. Thank
Is there
you.
anything in the record to support the house being a suspected drug house, or is it just called a suspected drug house?
It's called a suspected drug house.
Any
Your Honor.
additional facts developed?
Nothing. Who, what, where, when, why, and how. But take that out of the equation, that patient flatlined. And so now we come to the appellant's extreme, unusual nervousness. You know, the 3 most overrated things in life, French cuisine, Notre Dame football, and nervousness and a reasonable suspicion analysis. Don't take my word for it. Take this court's word for it. 4 decades ago, during the Reagan administration, this court made it clear that even the most innocent among us are going to be nervous when confronted with a law enforcement officer on a traffic stop or wherever. And in those 4 decades, this court and the courts of appeals in published opinions, as opposed to the fool's gold of non-published opinions that the state relies upon, have characterized extreme nervousness as being of minimal probative value, a weak indicator of narcotics, not indicative of guilt, and not particularly probative of guilt, and of course, never alone sufficient to warrant reasonable suspicion. But the state does what it has to do. It rounds up the usual suspects. It says the appellant's allegedly pounding carotid artery, which of course this court dismissed in Wade, his labored breathing, which I think is the stepsister of the wavering voice we see in so many of these cases, and my personal favorite, the impulsive smoking of a cigarette. And again, what the state hopes this court won't do, what the majority didn't do, is watch the video. I'll say it again. Watch the video. I have watched this video more than Caddyshack, and I am telling you that you will see that right up until the time this appellant is cuffed, he is compliant, he's cooperative, and he's as cool as the other side of the pillow. That's irrefutable proof. As Justice Scalia remarked in Scott versus Harris, the video in that case literally revealed a visible fiction. That's what they want this court to believe. In this court's cases like Carmouche and Tucker and the Courts of Appeals decisions in Thompson say, let's just go to the replay. Let's just look and see if they got the call wrong on the field, and clearly they did. And finally, the appellant's refusal to consent, and this is the no-brainer. This is the easy one. First of all, even if you want to consider it, what the state won't tell you is that the lack of consent happens after the purpose of the traffic stop is over. That's it. And under Richardson and St. George, information that the deputy receives after the purpose of the traffic stop is over can't be considered. And again, the state says that the refusal to consent is merely the last factor, not the prominent one. Seriously? It's usually going to be the last one. So what relevance does that ultimately have? And I want to talk about what I think we're going to hear a lot of in another 3 minutes and 45 seconds. Divide and conquer. It's kind of got a ring to it. Look, we acknowledge that, to be sure, that in some cases the whole is greater than the sum of its parts. This is not that case. You need to understand that divide and conquer is not a blank tile in a game of Fourth Amendment Scrabble. And that Judge Onion, God rest his soul, used to say that a good rule works both ways. Well, think about it. If a defendant on appeal can't accumulate non-errors into a harm analysis, the state should not be permitted to accumulate non-evidentiary factors in a reasonable suspicion analysis. And I said the good news is that we don't need to reach the larger question of whether this court should ever consider consent as a factor. You can leave it to the next case. If there are no questions about that, I just want to essentially say that those cases that the state has on 5 different occasions, and I have a funny feeling today's going to be the 6th, that they don't want to talk about, that we point out at pages 27 and 28 of our reply
I
brief.
have a strange fact question for you.
Yes, Your Honor.
What I have in front of me indicates that when the appellant's pulling in and out of the driveway or whatever he's doing first, he's wearing a black fanny pack across his chest. And when they do the search of the car, the fanny pack's in the car now. So, and that's where the drugs are found. So I'm wondering when this exchange from across the chest to in the car where the drugs are found occurs, and if perhaps that is another indicator that something's not right here.
One of my favorite answers, Judge Hervey, is I don't think that's in the record. And I don't think it necessarily has any relevance, again, viewed through the prism of the fact that there's absolutely no indicia of reliability about that suspected drug location.
Okay.
In United States versus Alvarez, Judge Stuart Kyle Duncan, probably the most conservative voice on the most conservative appellate court in the world, the Fifth Circuit remarked that the success or failure of a suppression motion cannot turn on an officer's saying, in essence, I know it when I see it. Well, that's exactly what Pope admitted. That's exactly what this record shows. That's exactly why this court must reverse the majority opinion of the Court of Appeals.
Thank you, counsel.
May it please the court. Mr. Wice, counsel. My name is Jeff Schell. I'm here on behalf of the state of Texas and the Rockwall County Criminal District Attorney's Office and its elected criminal district attorney, Kenda Culpepper. If there's one salient point I want to make here today, it's this: that Mr. Lall's refusal of consent to search was not the prominent factor in this reasonable suspicion calculus. It was the final factor in chronological order when other additional suspicious factors that this court mentions in Matthews were already sufficient to establish reasonable suspicion.
Counsel, should Should failure or refusal to consent to search ever be a factor when someone's exercising a constitutional right?
Well, I think in Wade, the late Judge Cochran said it could be. It could be a factor. It just could not be the prominent factor. And I think the court says that at 422 Southwest 3rd, 674 to 675. That's specifically what the court said in Wade.
Has it been affirmed through any other decisions by this court?
And then Wade was decided in 2013. Matthews comes a year later, in 2014. And in 2014, Judge Cochran also writes that opinion, with no dissenting opinions, by the way, from this court. And Matthews is distinguished. And they distinguish Matthews in a footnote, I believe it's number 33 on page 605, where the court says there are additional suspicious factors in Matthews that were simply not present in Wade. And I think that's what you have here. And I know Mr. Wice takes issue with that, but I think this case is more like Matthews than it is Wade.
Well,
Counsel?
oh, go ahead.
I was just going to say, so is there reasonable suspicion without considering the refusal to consent?
Yes.
There is?
Yes.
So
Yes,
then
there
why
is.
does it even need to be there at all?
Well, because
Why even consider it?
it could be segregated, it could be taken out
Okay.
if this court wants to. In the court below, the state made the argument that it could be a factor because it's in the findings and conclusions. Judge Brett Hall, who's the district court judge in this case, made a specific finding of fact. It's at page 63 and it's specifically it's number 9.
Okay, counsel, I think the question though is if we take that out of the equation altogether, what's the reasonable suspicion?
Okay, all right. Let me answer it directly this way. There's several factors. There are additional suspicious factors that are in play here. Number 1, he's coming from a suspected narcotics house where illegal narcotics activity is taking place or is suspected. Let's say suspected.
How do we know that from the record?
How do we know that from the record? Because Jeff Lutz, a sergeant with the ROCKWALL Police Department, testified to that fact. He testified that he was surveilling other houses in that area of ROCKWALL County as well. This particular house caught his attention because he saw the Mercedes that Officer Pope stops in a legitimate traffic stop. He sees that vehicle arrive at the residence. So he begins to surveil. And he begins to see what Mr. LALL is doing at this particular house. And yes, to Judge Hervey's point, you see he sees the fanny pack, the black fanny pack that he throws across his shoulder, and that is later found in the passenger side when the dog alerts. That's significant. It's also significant, and this is my second point, second factor. The second factor is that when Officer Pope asks for his driver's license, okay, his identification, he says, "Do you mind if I look for it?" And at that point, Officer Pope says, "Sure, go ahead." So what does he do? He goes to the back of the Mercedes and he starts to look around. But as Officer Pope watches his behavior, he's not looking for anything. He's just standing back there. And the reason why that is significant is because you know where his wallet is? His wallet's right next to the black fanny pack in the passenger's side of the vehicle. There's a reason why he didn't want to produce his ID. Because if he did, he might draw attention to the fanny pack that's in the passenger side floorboard. So the fact that he doesn't have authority to control his own vehicle and does not produce it to the officer when it was demanded is another reasonable
Does he ever produce
suspicion
it?
factor.
Does he ever produce it?
Does he ever produce it? No, he does not. Not during the stop. Now, Officer Pope finds the wallet later after the dog alerts, but he never produced it. And this is where I need to address the amicus brief that's been filed with this court. The amicus brief took the position as an alternative justification that the fact that he didn't have his driver's license on him was a violation that would have allowed the stop to continue. That's simply not correct. And to be candid with this court, That's just not the case. He was in possession of his driver's license. He had it with him. He just chose not to produce it, and there was probably a very good reason for that.
He gave his driver's license number, is that correct?
He did. He did give his driver's license number. And that's, again, why we addressed this in our reply brief that we briefed last week. We did it separately. We took the amicus brief to itself and said, look, the possession is a fact. He was in possession of his DL. So you can't make a justification under, I believe it's 521.025 of the Transportation Code. That was the amicus brief's position, that gives the officer the right to continue the detention. That's simply not the case. He had his driver's license, he just simply refused to produce it. Our position is, in response to the amicus, is that it goes to reasonable suspicion as a factor. It doesn't necessarily go to the right for that officer to make an arrest.
Okay, so third was the looking for the driver's license.
Yep, that's right.
Okay.
Okay, here's the next factor.
Counsel?
Yes.
You keep saying
Second,
he
excuse me.
refused to produce his driver's license.
Yes.
Have you ever got out of your car and went in the house and then, what do I do with my wallet?
Well, I usually have it on me.
Never leave it in the car.
I never leave it
lose
anywhere.
your wallet.
It's in this front pocket right here, actually, at this very moment.
Well, I lose mine a lot. And I
Well,
just can't see that when he wasn't able to find the wallet, how you can jump to the conclusion that he refused to produce it.
Well, I think you can make that inference. And I think the officer, under the circumstances, can also make that inference as well. That he doesn't know where it is. And he's deceptive and he's furtive in the sense that he says to the officer, do you mind if I go look for it? And yet he doesn't go to the passenger side door. Why? Very good reason. Drugs are there. He goes to the back of the vehicle, opens it up, and starts looking in the back when we know, in hindsight perhaps, that it's not there either. All of this kind of goes into the totality of the circumstances that Officer Pope is dealing with at the time of the traffic stop. He's trying to determine, why is he in the back of the vehicle looking for something that isn't there? He's not even looking for it. He's just standing back there.
Counsel, I think Judge Slaughter, did you have another question?
I'm sorry.
Oh, I was just waiting for the different points. So it actually covered one, suspected drug house, two,
We were looking for a
looking
wallet.
for driver's license, and so there are other factors.
There are other factors, yes. All right, let's go on to this next one. The next factor is his nervousness, okay? His nervousness is greater, it's extreme. The reason why the findings of fact are so important is because Judge Hall, in finding of fact number 8, says, during the stop, the defendant was extremely nervous. Not just nervous. This is beyond a little ordinary traffic stop nervous, that people are encountering police for the first time, perhaps. This is an extreme nervousness. And we briefed in our reply brief that the extreme nervousness is entitled to more weight, more probative value. More probative value than less because it's considered to be extreme. It never dissipates. It never stops.
I hate to interrupt this work that Judge Slaughter's getting with all the details, but how are we supposed to figure out what's the difference between extreme and regular nervousness? How is it that cops are supposed to, I mean, isn't that just going to come down to magic words like, he said extreme?
He said extreme, and it's going to be fact specific. It's like any reasonable suspicion case. It's going to be fact specific.
Does the video shed any light on that?
Really?
I think the video can shed some light on it if the court wants to look at that, yes.
Okay.
But let me answer your question more specifically. More specifically, I know we may be playing with words here, but extreme seems to have a connection in the law that says it's something else. It's not just nervousness. I can't find my wallet, Judge Walker. I can't.
Okay.
I don't know where it is. You know, you get nervous when you lose your wallet, absolutely. But that's not the extreme nervousness that we have here. The fact that Jordan Pope is an EMT, I think, is important. Jordan Pope is a member of the FATE Department of Public Safety, and in a small county like Rockwall, agencies work together in law enforcement activities. And Fate is one of those counties, one of those cities that employs both firemen and police. They're dually trained. So this officer has specialized knowledge under Ramirez Tamayo that allows him to make an inference as to what could be considered extreme. The fact that the carotid artery that he's an EMT and can recognize suggests it's more than extreme.
Isn't there the neck thing though in Wade? Isn't it the same sort of neck pulsing, attracting vampires? I don't know. I mean, they had the same detail and that wasn't enough in Wade.
It was not enough in Wade, but it's going to be enough here.
Okay.
And it's more here.
Okay. So what's the next
What's
thing?
the next in the equation? We're adding up. Okay. 1 + 2 + 3 is still reasonable suspicion. We've got the nervousness, we've got the drug house, we've got the carotid artery, we've got the nervousness that is, I've again described as extreme. He immediately, impulsively starts smoking a cigarette when this traffic stop begins. Officer Pope says that was unusual. He considered it as part of his nervousness. You've got the inability to produce the driver's license, and then finally we have the refusal of consent to search. All of this takes place within a very short period of time.
Short
The
period.
refusal of consent to search is within 2 minutes. And understand, when Officer Pope makes this stop, he's the only officer that's surveilling this vehicle. And he's the only one in a marked vehicle, and he's the only one with a dog. So it's not like we make a stop, wait 35, 40, 50 minutes, an hour, whatever length of period of time that Rodriguez might have a problem with. He has the dog deployed, and it alerts within 2 minutes of the refusal of consent to search. So can it be a factor? Yes. Is it a factor in this case? Yes. But even if you take refusal of consent to search out of this equation, take it out of the calculus, you still have sufficient reasonable suspicion to extend the traffic stop beyond it. Because Officer Pope, when he encounters Mr. LALL, encounters a gentleman that is simply not acting normal.
Counsel, what was the role of the officer who testified about the license plate being obscured, who
Yes.
was somewhat different than Officer Pope? What was her role?
Her role was Monica Figueroa. She was working with Sergeant Jeff Lutz in connection with this surveillance. They're both sergeants within the narcotics division of the Rockwall Police Department. Both of them are surveilling this house, and Figueroa is actually the one that starts to follow Mr. LALL as he leaves his residence. After he's done the heat run that Sergeant Lutz observes. And again, all of this is developing the reasonable suspicion to stop this car in the first place. The heat run, if you read Officer Lutz's testimony, what a heat run is in this situation is it's a vehicle that leaves the residence, goes up the driveway, comes to the county road, stops, pulls out, stops, looks both directions, and then backs back up the driveway to the residence. Sergeant Lutz goes to enormous detail in the record to explain what that means. The heat run is for a person that's driving the vehicle to determine if there is surveillance of what's going on. And that's significant here. That's significant here because this is what is conveyed from Sergeant Lutz to Officer Pope. And so when Pope, already knowing that there's an ongoing narcotics investigation, he encounters Mr. LALL and then discovers all these other things that further develops his individualized reasonable suspicion that then allows him to continue the detention beyond the traffic stop.
I'd like to ask one more question.
Where's my wallet?
About the video. Does the video make it obvious that the defendant was extremely nervous?
Can you see his neck popping.
I don't think the video is that good.
Okay.
But Officer Pope testified that he can see the carotid artery pumping, and if the
But
court
you can
wants,
see other nervousness on the video.
and you see other nervousness as well. That's correct. Page 97 of Volume 6 is where Officer Pope describes what he sees with respect to Mr. Law.
And the trial court made a finding.
And the trial court made a finding, that's right. And as this court well knows, almost total deference has to be given to those findings of fact. And from that finding of fact, along with the other findings of fact, you come to the conclusion of law number 3 that the trial court made, which was the evidence supported Officer Pope's reasonable suspicion that criminal activity either had or was occurring on the part of the defendant at the time of the stop.
I'm
Period.
very upset that in your numbering of facts, even though you acknowledged it in the beginning of your argument, you didn't put the fanny pack in your number of facts.
It is all in the equation that allows this court to find, under the totality of the circumstances, reasonable suspicion. And I'm sorry, I was never good at math. That's why I became a lawyer. Then you have the conclusion that the trial court made, number 4, at the bottom of page 64 of the clerk's record. Officer Pope's detention of the defendant for the purpose of the drug sniff by his dog was reasonable under the circumstances. And that's what, at the end of the day, that's what controls this case, is the fact that it was, under the totality of the circumstances, reasonable and not a violation of the Fourth Amendment. Unless this court has any other questions, I'm going to give my 2 minutes and 24 seconds back. And I thank the court. I'd ask the court to affirm the majority opinion of the Dallas Court of Appeals. Thank you.
Thank you, counsel.
May it please this honorable court. The state continues to tell this court that the appellant's invocation of his constitutional right to refuse to a search was not the prominent factor. We know that's not true. But like Hemingway said, and the sun also rises, isn't it pretty to think so? The video does shed some light on this appellant's allegedly extreme nervousness. It shows that he was anything but. And to the extent that the state can stand in the well of this court and make the argument that the allegedly impulsive lighting of a cigarette should play any role at all in its reasonable suspicion analysis is what one circuit court has labeled nonsensical. It was a very brief 2 minutes from the refusal of the appellant's consent until the deputy brought out Czar. The state wants you to believe that it cuts on their side of the ledger. I disagree. I think it's just the opposite. I think given the immediacy, there is no break in the causal connection. There is no attenuation of the taint. It's bam, 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 and that's it. And that certainly doesn't cut on their side of the equation. Why are we hearing about the heat run? Why? It's not in the trial court's findings. And under State versus Mendoza, it's as relevant as last week's lotto ticket. Trial court fact findings are in fact entitled to deference, to be sure. To be equally sure, when they lack even fair support in the record, this court is not obligated to follow them. Trial court fact findings are not an impenetrable force field through which even the most egregious Fourth Amendment violations like this can't pass. The state's authority on extreme nervousness, by the way, is there any other kind? Relies on 3 Tenth Circuit Court of Appeals opinions and a Wyoming Supreme Court case. In the grand scheme of things, I think they prove less than 0. The trial court's conclusions of law do not dictate the outcome in this case. They're not entitled to any deference. We are viewing those conclusions through the prism of de novo review. What would a Brian Wice oral argument be without one last sports analogy? In 1980, before he sent the U.S. Olympic hockey team out on the ice to pull probably the greatest upset in the history of sports, Herb Brooks told his kids, great moments are born from great opportunity. And that's what this court has here today. It has the opportunity to affirm the fundamental constitutional tenet that the invocation of a constitutional right shouldn't be subject to an extortionate tax, as the Supreme Court recognized 60 years ago in Griffin. And that appellant's right to be free from unreasonable detentions and unconstitutional searches does not turn on an officer, even if he is an EMT's hunch. And that, as the Supreme Court of Rhode Island said in our pre-submission letter of authority, to catch drug dealers is laudable, but to catch them by unlawful means is lamentable. And that's what this case is all about. This is not a close case. But jurists as great as Antonin Scalia and David Newell have said that in close cases, the tie goes to the runner. I ask this court to do what the majority below would not and could not, and what the state does not do. And by the way, this was the 6th time they failed to acknowledge or distinguish any of those 9 cases on a reply brief. I ask this court to reverse the majority decision of the Court of Appeals and remand this matter to the district court for proceedings not inconsistent with its opinion.
Thank you, counsel.
Let me ask you one more question.
Yes, Your
Is the
Honor.
light still green? Why, in the future, in the future, why should we never consider a defendant's refusal to consent to search in a case like this?
Because as we point out in our brief, and as Justice Peterson pointed out in dissent, a majority of the federal courts of appeals and a majority of state courts have concluded that it is irrelevant and that it just ain't right. And Professor Lefebvre has also joined that overwhelming majority of jurisdictions in concluding that it gives law enforcement the opportunity to do nothing more than to gild the lily by setting up a defendant and asking him or her for consent to search and then saying, oh, by the way, that's a really big deal like the state wants you to believe today. And it's ironic that we don't permit prosecutors to comment on a defendant's failure to give consent during the trial itself, but yet we allow judges to consider that as evidence of criminal culpability in the context of a reasonable suspicion analysis. And as Justice Peterson remarked so compellingly in dissent, when the exercise of a constitutional right is not just accompanied by an extortionate tax, but results in a finding of criminality, it's not a right. I ask this court to sustain our grounds for review, reverse the judgment below, and remand this case to the district court with instructions not inconsistent with its opinion.
Thank you, counsel. The case is submitted.
All rise. Oyez, oyez, oyez.